Welcome. Welcome to all of you. It really gives me great pleasure to introduce Sagit Moore today and to introduce Sagit as part of our lecture series here this year. This is the 10th anniversary of the Disability Law and Policy Program, and we've had a wonderful lecture series so far, and Sagit will not disappoint. Professor Moore is a professor at Haifa University in Israel and is spending this year at the University of Washington in Seattle. She received her JSD from New York University, her LLM from New York University, her JSD and her LLM from New York University, and her first degree in law from Tel Aviv University Faculty of Law. She's been a recipient of a number of prizes, including a postdoc fellowship at Berkeley in disability studies known as the Ed Roberts Postdoctoral Fellowship. She's currently the Director of Law and Health and the LLM program at Haifa University. She's co-founder and co-coordinator of the Collaborative Research Network of Law and Society, and the Collaborative Research Network focuses on disability studies, critical disability studies. And I have to say, to Sagit's credit, I've been marginally involved, but she really has worked to make this research group grow, become more popular. And I think during its first year and now since, there have been not just one session at the Law and Society organizations, but 4 and 5 sessions on disability studies. She's also co-founder and coordinator of the Israeli Disability Studies Network and a former law clerk to the Supreme Court Justice Aharon Barak of the Israel Supreme Court. She is the co-editor of a new volume about to be produced on disability studies. I had the pleasure of working with Sagit and 3 other colleagues on this volume, which was the culmination of a research and conversation group that we had in Israel during my year there, and then before and subsequently. And Sagit really, I can say, really without exception, that she is the leading disability studies scholar in Israel today. She's written in the areas of torts, disability studies, and bioethics. And today she's going to talk about this intersection between disability studies and torts, towards a disability critique of torts. But I also want to take a minute before she begins just to thank a number of people and organizations and colleges and departments without whom this would not be happening. And I've mentioned this at the introduction of all of our lectures in this series, that for me it has been truly my greatest privilege at Syracuse University to be part of a whole, to be part of a community of scholars, activists, students, teachers, community people who are really focused on, devoted to the development of the field of disability studies and disability rights in general. And without this cooperation and collaboration, we would not be doing anything about what we're doing, such as this lecture series this year. So I want to say formally, I want to thank the Disability Law Society, the Disability Cultural Center, the Beyond Compliance Coordinating Committee, the Cultural Foundations of Education of the School of Education, the NGO Transnational Initiative of the Maxwell School, the Women and Gender Studies Department, the Honors Program, the Center on Human Policy Law Disability Studies, Falk College, and the College of Arts and Sciences. I also want to thank the Office of Equal Opportunity and Inclusion Resolution Services for their support of our CART and sign language interpreting. And I want to thank Sarah and Michael, our sign language interpreters, for joining us today and helping us all feel and participate and included. I also want to thank Rob Conrad, who's been at the law school and really has been the without him, we wouldn't be getting the word out about this lecture series, and to Chris Ramsdell, who is my assistant in life and work. And it really is an honor to have Sagit here. I think that I also have to mention, it's not her first time here. Sagit came 10 years ago, so it's so appropriate that you're here now 10 years later, when we first started the Disability Law Policy Program. And my recollection is, I think, correct, that you attended the conference that Professor Beth Ferry, I, and others put together, which was the first conference of its kind that brought together disability law scholars and disability studies and education scholars for the first conference on disability studies in education. And Sagit joined us for that conference. She's here now 10 years later, and it's really a great delight. So I've told her to talk for a bit, and then we're going to save some time for questions and discussion. And she's happy to answer your questions, I think, for about the next hour and 20 minutes or so. Okay? So thank you very much for being here, Sagit, and welcome.
Okay. Just so I cannot thank all these institutions and programs, so I will thank Arlene mainly for inviting me to speak here before this audience. I think this is a great honor and great opportunity for me to present my work before you. And I think Arlene didn't mention that it was at the end, so I just put my little slide about the timing, which is I think is a great timing for me. I just presented my work about a month ago in Berkeley, and I said nobody knew about all these. Or not nobody, but most of the audience didn't know about all these like anniversaries. So this is 10 years to the CRPD and 25 plus years to the ADA. I just learned that it's 10 years to the disability law and policy program here. And also for me, it's very important to know that this is 50 years to Jacobus ten Broek's piece about the right to live in the world that was published in 1966. ten Broek was a scholar and an activist who was working in Berkeley, and he never got an official position there, right? And it was, but I think later on people just like happened to many other disabled activists and scholars, people realized how important his work was. And I think I'm sure that this was the first article to provide a disability critique of tort law. And as far as I know, it's the first article to provide a disability critique of law in general. And at the same year, 1966, he also published another seminal piece about the law of welfare from a disability perspective. And throughout this talk, I will also address the connections between torts and welfare. I think the two fields are really related and have a lot in common when we think about critically about the role of tort law in disabled people's lives and in our culture, legal structures. So I will return to this link later on. And finally, only for those who are interested in the Israeli, with some symbolism in the Israeli context, so it's like 18 years to the Israeli disability rights law, which is Chai in Hebrew. So this is also a year, this is a year of lots of anniversaries, as I said. So the rise of disability rights in recent decades in local and global, national and international spheres has changed the legal landscape of disputes that involve disabled people and that concern disability-related questions. This change has been not as radical as many activists and scholars would like it to be, but it still had an enormous impact on many fields of law, but mostly on public law and much less on private law and on fields such as tort law. Tort law, for some people are still asking me what is tort law, and I remember first time that I read the word tort, I was looking for it in all dictionaries and I couldn't find a translation to Hebrew. What is tort? So tort is the law of injury, and the law of accident is the law that is the field of law where people file lawsuit to get compensated. Today I will focus mostly on the field of tort law, and I will discuss in what ways was slower to respond to the disability critique, but at the same time why it is such an interesting field for a disability critique. I think that first of all, and it's almost undisputed, that tort law lacks a disability perspective. I want to call people for a disability to join the effort to provide a disability analysis of tort law, because tort law, as I will soon show, is in many ways all about disability, but people don't think about it this way. And I also think that once we take disability seriously, then disability poses a fundamental challenge to the very logic and very structure of the field of tort law. And in the end, I hope I will get to that. Ultimately, just as the disability critique poses a challenge to tort law, I think the tort law or personal injury law also complicates the understanding of disability through the perspective of unwanted injury and the extra costs of living with disability. So tort law does address these two aspects, which pose some challenges to disability theory itself. What does it mean to be injured, to experience an unwanted injury, and to face the costs of living with disability? Before I enter the realm of torts, I would like to briefly present the field of disability legal studies, which is the field that both Arlene and I are very are devoted to. I think that a very concise way to explain the field is to say that disability legal studies adds a legal dimension to the multidisciplinary field of disability studies and a disability perspective to critical legal theory. Recent years have witnessed a growing understanding that disability is dynamic, interactive, and social phenomena, but the field of critical legal theory was slow to respond to that. We still see, and me and Arlene had some conversations about it today, we still see that critical thinkers, feminist thinkers, critical race theory thinkers are very aware to the intersections of disability and of gender and race, but not as familiar with disability and with the implications of disability and with underlying assumptions about disability when we discuss gender and race and when we want to rebuttal some negative assumptions about women and about racial and other minorities. Adopting a disability perspective means, as most of you know, examining or at least acknowledging the relational, interactive, and contextual nature of disability. I would like to suggest that a thick disability critique of any legal issue, it might be relevant to other fields, but I'm in the field of law. So I think that a thick disability critique of any legal issue should incorporate, again, at least acknowledge the following dimensions: stigma, access, social services, and distribution. And I would like to add another aspect that I don't think is always relevant, but is many times relevant, which is the embodied experience of disability. It's the that connected to the field of the sociology of impairment and the social construction of pain, which is not always relevant, but in the field of tort law is very relevant because we talk about bodily injuries. So we cannot talk only about social construction, we must also acknowledge the bodily implications of disability. So when I talk about stigma, I talk about negative assumptions about disability or about disabled people as incapable, unfit, a burden, unwanted, inferior, of lesser value. Let me know if the captioning is, if I'm speaking too fast. Or living a life that is not worth living. The law plays a role here either by ignoring, legalizing, or sanctioning such practices. So the law has like different roles in reinforcing or fighting stigma. The law doesn't have only one role. It's not only an oppressive force and it's not only a liberating force. And the law doesn't affect our understanding of disability only by directly addressing disability, sometimes by ignoring the field, by not regulating a field, by not regulating access, the law allows a place to be inaccessible. So the work of the law is, in different ways, may reinforce a stigma or fight stigma. When I talk about access, it means acknowledging and studying, of course, the various forms of interpersonal, environmental, and structural barriers that prevent disabled people from meaningful participation. And here the law, again, can be very helpful and can also serve as can hinder social change. So these are two common aspects to discuss. I would like to put into the discussion also social services and distribution. The availability and nature of social services have an immense impact on the quality of life of disabled people, on the cost of life with disability, and on the ability of persons with substantial disabilities to participate in social life. For example, to live independently with the support that they need. This includes, in my view, all types of services and programs, social insurance, personal assistance, healthcare services, education, housing, supported decision-making, etc. These are all services that, to my mind, define the scope and the character of the welfare state. how much the state is involved, how many services the state or social services the state provide or support or fund or encourage that will be in society, even though they might also be a product of voluntary organizations. As to distribution, the distributive aspect of disability brings up questions of poverty and socioeconomic inequality. It is well known and documented that disabled people are disproportionately poor and that poor people are disproportionately disabled. This is one of the major causes of the marginal place of disabled people in society, but it is also a result of stigma, lack of access, and inadequate social services. So all these aspects are strongly connected, and it's very hard to discuss them in isolation. It is also, of course, strongly connected to the structure of the labor market, of the economic system, and I would like to add, because I would address it later on, to the structure of disability allowances. So when we want to talk about disability benefits, disability allowances, this is one way of the state to provide people with disabilities with some financial resources, but they're always inadequate, they're always at the minimum, and many times insufficient. The goal of a disability and legal studies analysis is to shed a new light on the underlying assumptions and the hidden structures of legal norms, doctrines, and institutions. The law is everywhere, and so is disability. And this is my opportunity to quote Arlene here. Every legal issue has a disability angle. This is true for many fields, but especially for law. And we usually don't look for this angle. We don't really get to talk enough about the disability angle of every issue. But when we want to talk about the disability angle of every issue, I think we should remember that the scope, I'm trying here to distinguish between two levels of, or two aspects of the disability critique, of the scope of the disability critique. And so the disability critique, we can say, has one dimension that addresses disabled people specifically. So it's disability as a discrete category of analysis and the study of disabled people in isolation. So what is the impact of this specific policy on disabled people? But what usually disability studies scholars would say is that this is not enough. We don't want only to study disability in isolation. We want to take disability as a general analytical category that serves as a prism through which to examine larger concepts, larger fields and institutions. So what does the disability prism or the disability perspective tells us about these fields? And when we want to look about this, at the disability critique of law, if we want to be more specific about the law, so when we think about disability as a discrete category of analysis, we can examine how the law affects disabled people and how disabled people interact with the law. But I think it's always important and always more interesting to connect it to the larger question of how disability serves as an organizing principle of a particular legal doctrine or legal field or legal institution. So here today I will not only speak about disabled people in law, but also about the law treatment of disablement. It's also about what is the role of disability in our understanding in other contexts of citizenship, of community, of productivity, of dependency, of other larger concepts that our understanding of disability permeates their logic, shapes their logic, and in a way that is often is hidden, is not really acknowledged. So when we talk about disability, I want to go now to disability legal studies and tort law. And I think that tort law is a central arena where the meaning of disability is produced, shaped, contested, and utilized. It's a neglected but very important field of analysis, and also very fascinating and interesting. The law in general shapes the meaning of disability, not only by determining the rights of disabled people, but also by defining who is disabled and who is not, who is responsible for a disabling event and for its consequences, what remedies and compensation schemes are available, and what values and attitudes shape those schemes. Tort law is particularly an arena where these questions are sorted out. It assigns responsibility for disabling events. It awards damages to injured persons to cover disability-related costs or needs and care. It deals with the process of disablement, the circumstances of becoming disabled, the bodily, material, social, and legal implications of disablement, and I think also very importantly, the envisioned trajectories of life with a disability. When involved in a personal injury case, lawyers and judges inevitably work under a certain set of assumptions about the nature of disability and its medical, social, and cultural meanings. These assumptions are shaped by societal views as well as the legal framework itself. In social legal scholarship, we say that law is a juridical field. Tort decisions follow a specific form. They speak to a particular audience in a particular language. They serve several functions, including persuasion, legitimacy, resolution of actual conflicts, and above all, they have real-life consequences. So when we think about tort law, we can see how tort law not only assigns responsibility, it also provides compensations. It provides actual money to people who were injured and need this money in order to have better life chances and better rehabilitation services. Now, as I said, the disability, there isn't much work about disability and tort law. I will address some of it, but the main field where disability critique is present is the field of wrongful life and wrongful birth claims. Wrongful life and wrongful birth is these types of claims that parents, okay, let me distinguish between them. Wrongful life claims are claims that brought in the name of a disabled child or a person against a healthcare provider for neglecting to detect the disability or the impairment during pregnancy and therefore losing the chance to abort the pregnancy and losing the chance not to being born. So the claim of the disabled person is, I would rather not being born than having this life, than living this life with a disability, because of disability. This is the wrongful life claim. The wrongful life claim in the name of the person saying, I'd rather not being born. The wrongful birth claim is a claim brought by the parents who said, we missed the opportunity to abort, to perform an abortion, to abort the pregnancy. So their claim is more about their autonomy that was infringed, that they didn't have the opportunity, this chance to decide that they don't want a disabled child. These claims are very controversial also for legal, philosophical, and ethical, for other legal, philosophical, and ethical considerations. Mainly, one major claim is that it's very hard to talk about the absence, about no life. It's not that there wasn't an option to live without a disability. This is the option of not living at all compared to living with a disability. We know nothing about the absence, about not having life. It's very hard to compare. And we also, and it's also very, it's the only field where tort law compensates for being alive. Tort law always compensates for being either injured or dead, but not for being alive with a disability. So just like, for the purpose of our discussion, I read all these cases in Israel, in the Israeli context, and what I found when I read those cases very carefully is that the sympathy of courts to these claims, despite their intrinsic difficulties, is rooted in deep empathy for the family, both for emotional and financial reasons. So the emotional empathy is expressed in the view that it is legitimate not to want to have a disabled child, or to prefer not to be born and live as a disabled person. This view is rooted in what has been called or been criticized as the Israeli race for the perfect baby, all this prenatal selection industry. Also in Israeli permissive abortion policy, de facto, officially it's forbidden, but de facto it's very liberal, a subject for a different talk, and general negative attitudes toward disability. And this is usually the story that is told. But I think that it's very important to address the financial sympathy of the courts towards these families who are facing a financial crisis. So I cited in my work many families who said, we need this money. We wouldn't have this, they cannot say that they wouldn't file this lawsuit that they filed it only for financial reasons. They cannot say that. But in the narrative of the claims and the narrative of the court, you really say that what the court tries to emphasize and the litigants is that they need this to have a better life. So they need these financial resources. What they actually need is to have the private funding to pay for better social services and for better opportunities in life. In Israel, in 2012, wrongful life cases were banned, were announced illegal anymore by the Supreme Court, who cited the basic law, human dignity and liberty law, and the equal rights for persons with disability law, saying a person is born in the image of God. Once he is born, his dignity and the sanctity of his life should be protected. There is no way to evaluate his life, as difficult as they may be. So we see that it's still not a full disability rationale, but it's still a way understanding that he says, the court says later on, the judge says later on, defining the life of a person with a disability as harm is inappropriate, immoral, and intolerable. So there is some sense that this is not something that we can say, in 2012 that a life of a person with disability is a harm, but at the same time, the disability language is not fully there yet. Sorry. So what I want to do is to extend this analysis generally to the field of tort law. Usually when tort scholars talk about wrongful life claims, they talk about wrongful life as a very unique and special and different field of inquiry. Like this is like an anomaly that is not explained in regular legal terms. I actually think that even though they are extreme, they tell us a lot about the very structure and logic of tort law in general. So the same things about this same tension between having an empathy to a person who was injured, that nobody would like to be injured and nobody would like to be disabled, and at the same time having a sympathy to the economic consequences of disability, they together shape the way the tort law is structured. But still, I think that tort law is missing a disability perspective on many levels. And I think that is important, as I offered previously, it's important to think about tort law from these two perspectives of disability as a discrete category of analysis and as a general analytical category. As a discrete category of analysis, first we have to acknowledge that disabled people injure and get injured. We have some research on that, but not enough. This is mainly today the field of feminist scholars and critical race scholars who talk about the way that women and racial minorities are treated in tort law. But we don't have enough research about how disabled people are treated by a tort law, except for one example, the person with a mental or psychiatric disability that commits an attack or a violent action. So this is the only field, and even there we don't see much of a disability critique perspective. We see it more as like a policy issue and a public health issue or a security issue, but not an issue of disability studies, and not enough analysis about the circumstances and the services and the general structure of society that puts people into that position. I mean, I talk about tort law, not about other fields of inquiry. So first, we need to think more about disabled people as they injure and get injured, and at the same time, we also should think more and more about tort law, especially personal injury law, as a field that is almost all about disablement. Most most tort cases are about people who are injured, people who get injured, which means that they became disabled permanently or temporarily, but it's their interaction with the experience of disability, of becoming disabled, and we don't see a lot of that. So the way I would like to call it from now on, which is maybe a little bit limited, but we should distinguish between tort law treatment of persons with pre-existing disabilities and tort law treatment of newly acquired disabilities. And what happens is a very interesting difference, that when we talk about tort law as a field of, when it addresses persons with pre-existing disabilities, what we see, and I will say a little bit more about it, is that it becomes a branch of disability rights. It becomes a branch of let's extend the protection that tort law provides to all people, to disabled people too. So if a blind person falls into a hole in the ground, they should be protected too. And if a disabled person is abused in institutional care, they should be compensated. So it becomes a field of dignitary torts, of torts as a defender of dignity, and as a branch of disability rights, expanding tort law to provide more protection to disabled people. And what I would like to show here is that when we talk about tort law and disablement, the cases where when we discuss people who are becoming disabled, these newly acquired disabilities, we actually get a different sentiment. We find a fundamental challenge to the very logic and the very structure of tort law. Whether tort law is the right way to respond to disablement, or whether it is a very limited way to respond to disablement that is insufficient in our society. And what I would like to offer is a kind of like a matrix between two axes of analysis. One axis is what I've just said, the pre-existing disability versus the newly acquired disability, or the perspective of disablement, which is not the same, but I'm struggling with it still. And the second is two types of critiques that I take from the four elements that I mentioned earlier, which is one is the disability construction critique, the critique of stigma, of access, etc. And the second one is the disability equality critique that comes from egalitarian and distributive justice perspective. So these are two different types of critique, and we don't, many times in disability studies, we focus on the social construction and less on egalitarian questions, but definitely in law and definitely in social welfare and torts, I think the aspects of distributive aspects should play a much central role. So when I talk about disability construction, of course, I talk about the understanding of disability as medical pathology, as a tragedy, and as a misfortune. And the term misfortune really comes again and again in tort law, particularly when there is no one to blame. So if we couldn't find someone at fault for the accident, so it's a mere misfortune. And for disability studies, the concept of misfortune is very different. It doesn't mean that there's no one to blame. It means that society actually denies its responsibility for disability, because disability is not only a product of the moment of injury. Disability is a product of ongoing social disablement whenever you meet a barrier of any kind. Just one second. The distribution critique, as I said earlier, focuses on socioeconomic inequality and on poverty, and it addresses the material conditions that give rise to disability, as well as to distributive implications of disability on the person's life. It brings up questions it brings up questions that relate to the role of society, different questions that relate to the role of society, through low sanitary conditions, too high exposure to environmental risks, lacking medical treatment, absent resources for appropriate assistive equipment, low enforcement of safety regulation, all that are ways through which the state is involved in generating disability through these crime, poverty, environment, etc. So the state here becomes involved not only by not being accessible, but also by being able to control, at least, even if not totally diminish, some of the reasons that give rise to disability. Now, I just want to skip some of that I've already said. So when we discuss persons with, just 1 second. Okay, no. Oh, yes. Okay, so when we think about people with pre-existing disabilities and we look about the disability construction critique, they raise a set of questions that concern to duty of care. I know that some of these terms are very legalistic, but duty of care and standard of care are the questions about what of the care or what are the standards that a stranger, a person, a member of society owes to other people. So if I dig a hole in somewhere, what measures of what standard of care I owe to other people around me? What measures should I take in order to prevent people from falling into this hole? And there are, of course, like much more complicated questions. So it's questions of duty of care, of standard of care, foreseeability, whether the person should foresee a disabled person coming, whether when I create a risk and I need to protect strangers from this or other people from this risk, whether I should take into account all disabled people with all their different characteristics, are they part of the protected group? And another aspect is, just as I mentioned earlier, is a different branch of claims of disability-based dignitary torts. So there's an excellent book and article about it by Mark Weber from DePaul University. So it addresses questions of abuse, neglect, lack of access, and discrimination. So you can really see, as I mentioned earlier, that this is a kind of disability rights orientation to tort law. And the result is pro and more tort law. The result is that we want more tort law and we want to use tort law to have a better society, to have better access, to have better or safer environment, better access, and better social services, even if we use tort law to sue against abuse and neglect. But I think, and we do have some work on that, not enough, but some work on that. But we are missing, I think, is the work about distributive aspects of people with pre-existing disabilities. The egalitarian critique of tort law talks a lot about the wage disparities and their impact on compensation. So if a rich person and a poor person are injured at the same opportunity, the same event, same circumstances, there is a category of wage loss, of loss of income. And in that category, their compensation will be vastly different. And this is a field of critique that was also extended by feminists and critical race theorists. But there is no such argument with regard to disabled people, about people who are either working for less or earning nothing. So what is the meaning of someone who earns nothing? Does the injury means nothing? Is it like zero? What is the social value of this injury? How does the law respond to someone who earns zero? There are some replies to that in tort law, of course. I'm not the first one to raise that, but these questions were not raised with regard to disabled people. And another aspect that relates, another distributive aspect is the impact of socioeconomic disparities on litigation dynamics. We know that poor people or less affluent people, they are less aware to injuries, less likely to file a lawsuit, less likely to win their lawsuit, less likely to win a lot for their lawsuit. So socioeconomic disparities have an impact on litigation dynamics as well, and this is also a field for a disability inquiry, I think. I'm sure. But the more exciting field is as I said, is the field of newly acquired disability. So if the disability construction critique starts bringing questions, and we have some scholarship on that about disability as tragedy. Tort law, in order to win a lawsuit, you have to perform the worst of your disability. You have to be there, and you have to be miserable. You have to be unable to, unable to work, unable to regain your life back, because I say it like cynically, happy litigants do not get as much as sad litigants. You cannot come and say, well, I regained my life back, but I really want all this money that I need to be able to live this not good, but it's like functioning life that I have. So lawyers have a role here in pressing this performance of misery and tragedy of disability, and judges, and here juries in Israel, we don't have that, they expect for this performance. And it's very hard today for the law to get a much more complex and rounded understanding of reality of living with disability. It's very hard to come with a mixed narrative of, well, it's good and bad. And there are difficulties, but there's a lot of joy and other issues that disability studies usually pressure. It comes into play in the question of pain and suffering and other issues. But what I really want to emphasize here is that what tort law doesn't do is that it doesn't address largely. I didn't see a court decision that does that very strongly. Doesn't address stigma, doesn't address lack of access, and doesn't address lack of social services as the reason for this, as the driving forces behind tort law. And I think that when we get to the distributive critique, this is really getting even deeper, because it gets even deeper because what we see is that tort law becomes a mechanism of screening who will get the package of tort benefits, and this is the people that the US media really likes to hate, right? All these like frivolous lawsuits, all these people who file those frivolous lawsuits, all those frivolous lawsuits are based on a very specific calculation of the cost of life with disability. Of course, some lawyers may be exaggerating and maybe send people to medical experts that shouldn't go there, but in general, life with a disability are expensive life. So a person who was able to go through all the ordeal of tort law at the end gets like this huge amount of money, some of them. And other people settle for money because of the shadow of tort law. But at the same time, many people do not file lawsuits at all. They fail in their lawsuit. And what happens is that they don't have the resources to have a decent and dignified life. What they have is the welfare system to rely on. So what this critique, okay, so before, this is the last slide. So this critique leads to is an understanding that we should think about the relationship between social welfare and tort law. If we would have, and this social welfare and disability rights versus tort law, if we would have like better social services, if we would have a workplace that is more accommodating, and we would have less stigma, etc., etc. So just like imagine this disability utopia. So the role of, so this is, okay, it's just like an exercise, but just to understand like the scope of the critique, even though it might not be realistic, right? But if you imagine a disability utopia, the role of law is really changing and the amount of compensation is shrinking, because wage loss might not be as big as it is now, because more people will be able to go back to work and gain more money. It might be still a gap, but not that much of a gap today. Social services will be there, so medical costs and other costs will be not as expensive. And it also gets to the question that is extremely controversial, at least especially in the US, but all over, but I know that Finland just started with it, universal income. Maybe we need to think differently about the social welfare structure and about providing people with the sufficient funds for living dignified life. And again, I cannot really respond, have a definite answer to all these questions, but it's really, I think, interesting to think about tort law in relation to social welfare law or social security law. at the end, I don't have time for that, but I think it's still very interesting to think about two concerns and complexities. First, disability utopia is not here, right? And if it will ever be here, it's going to take a long time. So tort compensations for now are the only state-sponsored mechanism to get the sufficient financial support that a disabled person receives. This is the situation. So people say, in the name of like a social change, of like a promise at the end, you want to take this avenue of compensations, avenue of financial support. It's very problematic. And the second concern, coming more from torts, as I said, like torts challenge to disability critique, that injury is an unwanted experience. And even disability studies scholars would agree that injury is an unwanted experience. And the question is, how do we respond to that? Because tort law doesn't only compensate. Tort law also sends a message about moral judgment, or about that someone did something wrong, and also a message about safety, about how to make society safer in the future. So this is the question of prevention and deterrence, but I like safety the most among these three. I was looking, it took me a lot of time to find the term safety. I don't like deterrence for some reasons, and I don't like, and prevention is good, but not enough. But safety is the actual concern here. Safety, how do we make sure that we live in a safer society? And these two questions they do raise the need to think about the role of tort law or alternative mechanisms to tort law that brings these two, that takes care of these two. And we know that all of them are not perfect. We can talk about safety regulation, but you know that regulation has its own problems. We can talk about criminal law and disciplinary law and other administrative avenues to bring moral judgment, but I still think it's a challenge, and I think it's important to think what is the role. Let's say, let's end it this way: what is the role of law in the disability utopia? So just assume that everything is there. Does tort law just or at least personal injury is gone, or does it still have a role with, moral judgment, safety, and maybe some extra compensations to those who were wronged in their injury, that their circumstances of injury were a result of a civil wrong. That's it. Thank you very much. That's a lot, I know.
I'd be happy to take some questions. But if you ask a question, please take the microphone and just press the button so that it turns red, I believe, in front of you before posing a question. Any questions? Comments? Oh, shoot. You have to get your own chair here. Sorry about that. Any questions? Go, Kate. Just introduce yourself and maybe just how you're here. Yes.
Hi, is this working? Okay. Hi, my name is Kate. I'm a second-year master's student at the School of Ed, and I also do disability studies. And I was reading about universal income the other day, actually, so it's kind of prescient that you brought that up. And here in America, my worry is that it would meet a lot of opposition because of the sort of ideals that are often espoused, American exceptionalism and this sort of rugged individualism that are valued by some. And I was just wondering how would you address that as maybe an argument about why universal income would be beneficial in the face of a country that kind of values those things?
I think you're very right. Press the button. Can you hear me? I don't have an answer to that. And this is, I think, the greatest frustration for people who truly believe that this is a good solution, knowing that it's like the resistance is huge. This is why this is impractical. But I can explain why is it what I think that universal income may replace a lot of other welfare mechanisms, very complex social security and welfare mechanisms, and all these other administrative costs But usually these people come from, so these people usually come from economic perspective and perspective of a cost-benefit analysis. And I think that it's very, I'm serious, if someone can help me answer people who don't believe in this, in kind of like, social welfare mechanism, because the problem is that it's even before that, right? Even just like raising disability allowances and allowing people living on benefits to have like a dignified level of benefits, that even is very controversial. So universal income is like, I have no idea. Definitely, but I still think it's right. But for disability benefits, I think that it's important, I mean, at least from my experience, from my research in Israel, we can see that, for example, disabled veterans in Israel, disabled of the Israeli military, they do get higher level of benefits. They never lose the benefits, even if they work, and higher percentage of people work. So it means that all this concern about the poverty trap or the allowances trap and the concern that people would not like to work if they will have their allowances is not accurate, is insufficient. People, if they have the economic security to move on and to develop their own career and work that they want, so they will do that. This is my opinion. I think it's a very interesting example to look at other groups who do get disability benefits, who never lose them, even if they work, and they still go on to work and they still develop their careers. They're not saying, oh, I have an allowances, so I don't have to do anything. And of course, the reasons why not going to work in an inaccessible workplace, workforce, etc., are much more complex than just not giving up my benefits.
Thank you.
Hi, I'm Rebecca Garden from Upstate Medical University. So I think there was just another study out today about the correlation between poverty and disease and health, ill health. And I think there's more of a correlation between poverty and disease and health problems than, so-called obesity, which our American Medical Association has turned into a diagnosis in itself, which is kind of a metaphor or a fabrication because it correlates with disease sometimes, but not always. So to me, it would be much more believable to create a diagnosis out of poverty. So when you have that correlation between disease and poverty, it doesn't make sense not to address poverty as a public health issue. And I've started to use the sociological framework of structural violence because some of the language used to define structural violence actually refers to impairment. So it starts to actually sort of concretize in terms of embodiment the effects of poverty. So I feel like that's something we could do more to drill down on and sort of lock into in order to make a stronger case. And in bioethics, it seems like poverty is just too big, and so people feel like, well, this isn't something we could possibly address, and yet it's responsible for so much harm.
Yeah, I personally think that poverty should be really part of any analysis of social issue, and I think that the disability critique really, in my mind, it really goes to eventually to the poverty critique. I think the history of the category of disability really shows that the lines between the poor and the disabled are very fluid, and they depend on the period, they depend on the time, depend on economic conditions. There's a very good book about it by Deborah Stone, The Disabled State. So there's a long history of drawing the line between the idle poor and the deserving poor. Who is deserving to get benefits and who is not? So I think poverty, and so I think the disability, and also the disability critique extends now to illness and to chronic illness and all these other categories. And the social construction of obesity is really, I think, related to these issues. I totally agree.
Thank you for the talk. I am Peter Bell. I teach tort law So I hear all this in the framework of tort. And one of my questions, as I'm listening to the parts that I was able to hear, I'm thinking the person in tort cases, the lawyer, who's likely to make use of disability theory is the defense lawyer.
Right.
And I think of the defense lawyer as using this in two ways. One, taking understandings of disability as both a disability, but also as an opportunity. There is using and discussing and using the disability literature as emphasizing both the dignity but also the richness. That disability creates some things that aren't, some paths you can't take, but also creates opportunity and emphasizes the richness of the lives of people, persons with disability. And the defense lawyer does that to minimize, in the minds of the person who awards the injury, minimize the harm that has been done to the plaintiff by the defense's misbehavior. The second way I see this, the defense lawyer is saying, and it's not really us, the defendant, with our wayward driving or our wayward doctoring or something like that. It's not really us that's created at least the whole of this injury that the plaintiff has suffered. It's the society which inadequately treats and responds to the conditions of persons with disability. And then the defense lawyer sits down,
I rest my case.
nice and smug, and the person with disability is furious.
I agree. Yeah. I think this is why this is really. This is truly my response. This is why it's so intriguing and interesting. I think that one of the problems here that I agree with you, and even in the wrongful life context in Israel, this is what we've witnessed. So the lawyers who brought the disability rights-based arguments were the lawyers of the insurance companies, and they were the ones that claim, well, now there's, and also for both in terms of of responsibility, of liability, so there is no such thing as wrongful life. And at the second stage of compensation, well, we shouldn't compensate as much because people with disabilities have so much life opportunities now, so wage loss is not 100%, maybe 20%. And I think it's a major concern. I think it's very important, and I would like to add another conservative layer to that, which is tort reform lawyers that may say, yeah, let's, this uneasy alliance between disability studies and conservative and other and conservative voices in other contexts where tort reform says, so we don't need so people don't need this high, if they live such wonderful life, they don't need all this huge amount of compensations. But I think the problem here is that, of course, the defense lawyer is the first to jump on it, but if we will teach judges to listen to these complex narratives of disability, even in the interim period, before we get to this phase where everything is beautiful and utopian. So the defense lawyers will not be the only one who will be able to enjoy this kind of argument. I think that if judges learn how to listen to these kinds of narratives, and defense lawyers and plaintiffs' lawyers can use this argument in a more sophisticated way, I think they can have a better work there. So the problem is that the defense lawyer, in a very ironic and cynical way, jump on it, but there is no general change, general awareness to this kind of arguments. And as always, it's a change that should be broader. But I still think it's a concern, and it's actually I think it's something that I actually intend to study, at least in Israeli case law, to read cases and to see whether in recent years there's been a change in compensation, in the rhetoric and whether the disability rights turn brought like less compensations in terms of wage loss. So whether courts and lawyers say, well, so this is where the roles change. Like that, of course, the plaintiffs have the incentive to play as miserable or as unable to work as they can. And I think this is why it's interesting.
So thank you for talking about the wrongful life cases. So I was following along and I was like, I don't know what tort law is. And then as you explained it, I was like, oh, okay. And so as you got to the middle, I thought about a few of like how often you see on TV lawyers who are specifically speaking to cases like wrongful life cases. So if you have a child with cerebral palsy or Erb's palsy, call this law firm to talk about like this idea of wrongful life or something like a major issue happening. And I tend to think to myself, like, who are the people who call and like, why are you calling? So it's usually not, though, from a disability equity standpoint, right? It's from that kind of conversation that it's usually something was wrong and something is wrong and someone has to pay for it. But oftentimes, if I think about families, like when they start to think in that way, where they go to sue, that kind of construction is often given to them as like the language, right? As to go forward in their lawsuit. So I guess I wonder, in the cases that you study, who were the ones bringing suit? So not who were they suing? What did they look like? Who were those folks who brought these forward, both wrongful life and wrongful birth?
I would really like to have this kind of research. I was only reading the cases, but I think it's fascinating. It's very important. But from what I read around it, many people who filed these lawsuits didn't tell their kids or didn't tell anyone in the family that they're running this lawsuit. Sometimes, I mean, the lawsuit is in the record, so sometimes you can just Google and find them there. So I wonder how much they think that in this information age they can hide this lawsuit, and not all of them are anonymous. But many people do that because of this. This is why I try to explain this complexity, that it's not only against disability, it's also because of the inadequate socioeconomic conditions in which people need to do that for their kids. So they fight for their kids through the tort system, and they have to say horrible things about their kids in order to get these benefits. And this is where I think it becomes really even tragic. So I have this citation it's a rare citation of a mother saying in court, I love my son now, he's the light of my life, he's an amazing son, but if I would abort this pregnancy, I would have in 1 year the same son, but with an arm. So the only issue was lack of an arm. And this was, she said, like in 1 year I would have the same son, but with an arm, which is, in general, it's impossible. In any way, it's impossible. But I think that these parents are put in this very difficult position. But the type of cases that you addressed they might be different. So these cerebral palsy cases, they might be medical malpractice and not wrongful life. Medical malpractice might be that during delivery, because of all kinds of complexities, the medical team was negligent in some way. Sometimes it wasn't, sometimes it was, but families want to find out whether there's someone to blame in order to get the money, and because they are raged, that they were supposed to have a non-disabled kid, and now they have a disabled kid. But so I think that this also raises the question: where the line is drawn? So there are so many cases that people lose. There are so many instances where people cannot file a lawsuit, and then we have this wrongful life, these very strange wrongful life cases where the court are doing legal acrobatic to save these several petitions that were able to get to but so many other people lose all the time or don't even file a law. So this is why I think that wrongful life claims are very important, because they serve as another mask. They don't really, they lead us to think that the judges and the court really comes to save everybody who needs this help and needs the compensation. In fact, so many people need this money and they do not get them. And this culture of like individual blame is very problematic here, because if society would take responsibility by social services and through access, combined, then it wouldn't be so devastating to become disabled or to have a disabled child.
I want you to take us into the world of disability utopia. And I want us to think about, in that world, I can help you get there. I would imagine that people are valued for their differences, that we recognize that disability is part of the human experience, that people see, think, act, walk, do things differently. And that's a valued good. So in that disability utopia, which is kind of a disability studies perspective on disability, how would we then approach the issues to both, I have 4 issues, but just one, say how to hold doctors responsible for violations of standard medical practice. How would we also then try to provide greater resources and distribution of resources to support the lives of people with disabilities, if everyone is kind of equal in their difference? Anyway, I have a few more, but I can talk to you about. But so how in that world can we still hold doctors responsible, for example, in the medical malpractice context, even put that as one example? Is that clear for everyone?
Yeah, I think this is like the second. Yes, this is the second aspect that I don't have a full answer, of course, because I'm only raising questions. So this is the second aspect of injury as an unwanted experience, and as something that, as a society, society has an interest to prevent disability. And I think in that sense, it really reminds me of Adrian Ash's work about prenatal testing and disability rights, contradictory or compatible. And it brings the same question here, like tort law and disability rights, contradictory or compatible. And of course, like the easy question is, we don't live in a perfect world. But I think that I was studying that in a non-disability context. How do we make like, I have a piece called Relational Malpractice, saying that malpractice in general interferes with the relationships between patients and doctors, because the medical field becomes a battleground, and defensive medicine and all kind of other problematic practices that develop following malpractice. But at the same time, we want doctors to pay for. But not only doctors, 90-something% of tort claims are not between 2 neighbors, fighting over a dog. It's big corporations are there and big money is there. And the problem is, this is why I said, it has this kind of conservative tone that's saying all corporations will now say it's not our fault, it's society's fault, and So I think that safety has other ways, there should be other ways to promote safety. In New Zealand, for example, which is always for tort people, it's always the example, they had a comprehensive accident insurance through their social security system. So it's a no-fault, it's a kind of like social security no-fault general system. Every person who was injured in an accident was receiving kind of social security benefits. It's much more complex than that. It changed and went up and went down. But the head of this organization was visiting Israel, and all the economic people told her, what about deterrence? And she said, we have a registry of any accident, and if someone goes over, it depends on the field, if a doctor has if we have 5 times, a registered accident that a doctor was involved, he gets a notice. After 10 times, it's not the numbers, I'm just after 10 times, we take his license. She told them, you don't know anything about what's going on. You have no knowledge about all these settlements, all these things that never happened. So it's it requires a different thinking about about licensing, about other administrative and disciplinary measures and criminal measures when necessary to address these issues. Also, there's another field of learning systems. So what happens now in hospitals, for example, they have their own departments of risk management. Usually we think about it as a bad thing, of avoiding the law. But we could think about risk management as a way of big institutions to learn from their own mistakes. And if you can learn from your own mistakes without the legal shadow above it, you can do it much better, because you're not afraid to say anything, because it's and one example is always the Israeli Air Force. I don't know if like American Air Force is always is also an example. Israeli Air Force had lots of accidents. They developed this like internal investigation culture. Every day starts and ends with internal investigation, and anyone who had any mistakes come on the stage and comes clear. Tells about the mistake and with no consequences, like unless it's like, you know. So accidents were reduced dramatically because there was a culture of learning, of organizational learning was developed. And so there are all kinds of ways that, you know, we don't even think, I probably don't know about other ways, but there's other ways to promote safety through regulation and through learning and through other measures that, or registry of accidents that can help us actually becoming like a safer society much more than torts, which I don't believe it's really effective.
Thank you very much. I'm a little bit confused. I'm from the School of Education, so torts to me is alien territory. But I'm confused about the overlap between the use of and I'm not saying it's your use of the word, I'm thinking it's the legal system, injury and disability. I feel there's a little slip and slide here. So would you say that all injury is disability? If you had to draw a Venn diagram, would they overlap completely, a little bit, a lot? So I think...
No, it's an excellent question. It's okay.
So is there a distinction between injury and disability?
Yeah. I think it's a very good question, and I think that in some ways, when we think critically about disability, we can also think more critically about injury, about the different aspects of injury. So injury is the bodily change, the bodily transformation that you go through, and also the social meaning that is attached to your experience following an injury. But so I'm trying to focus on what is called like personal injury. So it's like more bodily injuries, but they might also be in all aspects, like, you know, mental, emotional, cognitive, and bodily. But we also have other fields of injury that are dignitary injuries. So if someone is so libel and defamation, and you know, and discrimination in some sense can also be a source of like an injury to the person. And I think this is a field that is like outside this analysis that I'm not really sure how to, and this is also one of my responses, that this is what we might have after we lose tort law. We might still have dignitary torts. But I think that the disabling aspects of injury can be addressed through this analysis, and I think that many injuries that people think of may be still reduced with a utopian welfare system. Because if we think about hate crime, for example, so there is hate crime, so there is the aspects of, or victims' rights, so victims of violence, say, no, injured people, persons who were injured with violence. So what happens now is that we work about every category. We try to think about why every new group has a new justification to receive benefits at the end. So there's the aspect of saying why this is wrong, and there's the aspect of being compensated to be able to heal from the injury, you know, even if it's just so. But if we would have like better social services, they would cover a lot of that in many types of injuries. If you could go, like, if you could get like a psychological treatment for an affordable price for every person, and being able to, and at the same time have like other measures to confront other aspects of it. So I'm not really sure what kind of injuries you meant to, but I think that it doesn't cover all injuries, but it covers like bodily injuries framed broadly in mind.
If I lose my teeth because I trip over something that was negligently put, does that make me disabled? I surely can sue the person who negligently put something there and have my teeth fixed. But I question whether that would make somebody disabled. On the other hand, if I tripped and lost both of my arms, would that be considered disabled? Because I see disability, as you said before, or somebody said, a disability. And the word ableism doesn't come in to any of the discussion here when we talk about tort law. And even in your utopia, you say it's a disability utopia. What happens to ableism in that case?
I thought it's there.
What?
I didn't say the word ableism, but I thought it's there. But it's like it's two different questions. The question about the tooth, for me, the question is very good because at the basic there are two aspects: whether you lose your both arms or whether you lose the tooth. There's like there are several aspects of it. First, the financial. And if I don't have dental insurance and I don't have maybe all kind of complications come and I just want to fix my tooth and I want to make sure that it's a good, new health conditions. At the same time, I'm very angry with this person. So this is the question of moral judgment. What should we do with the fact that we know that somebody did something wrong and how should we address it? And I maybe want to make sure that it won't happen to anybody else. But these are the three major, motivations. So the question is so about the tooth, yes, I mean, in disableist utopia, in a disability utopia, which is the opposite of ableism for me. Ableism is all the stigma and access, etc. So, your tooth will be fixed, and then the question is, what do we do with the dignitary insult, the fact that somebody interfered with your autonomy and made you tripped, and what's the price he should pay for that, or maybe whether you should be compensated for that, for this discomfort. But maybe we'd have like a compensation for infringement of autonomy. We do have that, but they are much lower than the other compensations. Here, again, I don't want to ally with the tort reform, with like anti-tort people, but if we think about what do you want to compensate for, we might have like a limited field that gives you the more limited compensation for losing a tooth. I don't have like answers. I think that it's like this whole set of questions are together are related in some way, and we should try to distinguish between the different aspects of the injury, of what does it mean to what do we try to fix, what we can fix, and with what measures.
It sounds like you're pushing. The way the tort compensation works is you have to show lost income, and I think what I'm hearing you say is kind of pushing or using disability as another way of looking at that, and so kind of a loss of dignity from losing a tooth doesn't make you a person with a disability, certainly not under other laws like the Americans with Disabilities Act, so that if you're not hired because you don't have a tooth, you wouldn't have protection under that law. But the disability perspective sounds like you're recognizing that a loss of the dignity or an infringement, or I live in a poor neighborhood where all the sidewalks are not taken care of, as opposed to another neighborhood where they are, should be part more of how we look at kind of redressing the injury. I think that's what I'm hearing, than the person's identity as disability. That's what I hear kind of you saying a little bit. That makes sense.
It's also extending, bodily injuries are very...
Yeah, but bodily injury is not necessarily equated to a disability. So that's, Okay, any other questions, comments? Peter, one more. Yes, please.
Just when you were talking about the various systems and other ways to provide safety, to prevent injury, one of the things that I was thinking of is the tort system puts the power in the hands of the person with the disability.
Yeah.
They can decide whether to use it or not. The other kinds of systems put the power in the hands much more of sort of more independent decision makers, legislatures, creators of societal compensation systems, etc. And I just, in the whole calculus of what should be done, it doesn't seem to me that that should be entirely lost.
Yeah, I think one response is that today the power is the end of the person, but the power that it's a kind of, I don't want to be too harsh, but it's a kind of a false impression that anyone can file a lawsuit and then get redressed. So we don't want, I agree with you that I'm getting to another extreme that is also problematic, but today the promise of tort law is a false promise for many people. So when we go to more egalitarian, always like the more egalitarian regimes and solutions are less about like the liberty and the empowerment of the person. And I agree, I mean, in some systems, like you probably know in Scandinavia, a person have an option to choose between the no-fault avenue and the tort avenue. And this might be the solution in some cases. And again, maybe a person can, maybe we can design some systems that people can initiate, safety and other ways of, making sure just that the systems will work. Just like the criminal justice system is facing these difficulties, that the people who are injured, the victims of crimes, do not have a voice and do not have a place in the criminal systems. And we try to change that. So I think it's another important challenge, but I think that there's a lot of, like, David Engel had this like work about lumping injuries. So many people are lumping injuries for so many reasons. They don't file any claims for all kinds of reasons. So I don't really see today's tort as really an avenue of empowerment and power for the individual. I think that if you don't have a good lawyer, your chances are very, very low.
On that note, keep away from coal, don't. I want to say thank you so much to Sagit. I think it was a wonderful talk, a wonderful discussion. Thank you. I want to thank you all for coming. I want to also make a pitch for next week. Next week will be the final speaker in our lecture series. That's Sue Swenson, who's the Deputy Assistant Secretary at the United States Department of Education, who's going to be talking about inclusive education. And I hope you'll come. Her talk is Monday at 4 o'clock. I also want to make a pitch to the students in my class. If you haven't signed up for your presentation date, please do so. Kate has the sign-up sheet over here. And I hope I'll see you all again. And thank you so much for coming, really.